Hello, my name is Christina Jimenez,
And I am Josh Floyd.
and he and I are both board certified family law attorneys here in the state of Texas at the Jimenez Floyd Family Law Firm. And we have several offices here in the DFW area and also in West Texas. We have an office in Dallas, Louisville, Flower Mound, Bedford, and then we also have two over in West Texas in Odessa and Midland. And today we're going to talk to you guys a little bit about child custody in Texas. And so, Floyd, we have several topics that we're breaking down today, just brief overviews. If you guys are interested in deep dives on any of these issues, then we have a whole library of different videos that you guys can search for and watch. We just want to give some general information about child custody.
Yeah, this is one of those topics you talk about for hours because there's so much that goes into each one of these aspects. And so, kind of give a brief rundown. First, let's start with, I guess, how it's decided, like what the courts look at to determine, whether it's going to be a joint custody, when they're looking at the child custody stuff. So,
Yeah. So typically there's two different types of custody, right? So that's joint managing and sole managing. So maybe let's start there and kind of breaking that down. So what's the difference between joint and sole?
so joint managing, uh, both parents have the exact same rights and duties. And so, the way I like to explain it is there's really two sets of rights. You have your information rights and then you have your decision making rights. And so when you're talking about a joint managing conservatorship or joint custody, um, both parents have the exact same rights, except one parent will generally have the exclusive right to designate the primary residence, and the other one will not have that. With the sole managing, you have sole managing and possessory conservator. One is sole, one's possessory. The sole managing conservator will have both rights, the information and the decision making rights. The possessory conservator will only have the information rights and not the rights to make any decisions.
Right.
So that's the difference in joint custody and the sole managing.
And so it's actually presumed that parents should be appointed as joint managing conservators. However, you can rebut that presumption by providing certain evidence, right? And so one of the biggest ways that we see one parent being appointed as sole managing is because there's some instances of family violence, right? But it can also be because of drug history, the parent not being present, all sorts of various reasons that the courts can consider when appointing joint and sole, which kind of gets us into what we call the Holley Factors, right? Yep. Do you want to kind of explain some of that?
Sure, yeah. So the Holley Factors basically just sets out, and it's a non-exhaustive list, right? But it just sets out several factors that the court should determine or look at to determine, joint custody or sole or where the child's going to live and things like that. And so, a couple of things that they look at the parenting abilities. Um, you know, um, they look at the child in danger, whether the child's been in danger. They look at the stability of each party's home, how involved each party has been. There's like 8 or 10 of them.
Yeah, there's a bunch of them. So I wrote them down.
So
And
I did.
so,
I did write them down.
so
Going from
they'll,
memory.
they'll also look at needs of the child, co-parenting, the wishes of the child, and if there's any alienation. And so, kind of the abilities obviously is pretty easy. Your ability to provide stability is obviously important to a kiddo.
Ability to provide stability. I like that. That's a
Thank
good
you,
ring.
thank you. And so, obviously, if you don't have stable housing, or if you're in between jobs, like those are going to be things that the courts will consider. A big thing that we see is ability to co-parent. That kind of goes hand in hand. Yeah, it kind of goes hand in hand with alienation. And at our firm, we preach about co-parenting and not being difficult with the other side, because number one, it's healthy for your kiddos, but number two, it's also a really good way to get some losses in your case. And so, alienation, what is that?
So it's when one parent, I guess, alienates the other parent, right? Interferes with their ability to have a relationship with the child. Um, if you read through the family code and the different presumptions and stuff, like you were talking about the presumption of joint custody, it's public policy, really, of the state of Texas to I guess,
have a close and continuing relationship between a parent and a child.
But I would say to encourage co-parenting, right? Okay. Through the joint custody presumption, through the presumption about the public policy regarding the close continuous relationship, right? And so I think Texas kind of looks at it like, we want you guys working together, right? We want you guys to jointly parent these kids. And if you're not co-parenting, that's going to definitely be a mark against you. Especially if it's through alienation, right? It's one thing just not to co-parent, but it's another thing to interfere with the other parent's relationship with the child. Hiding the child, talking badly about the other parent.
Mm-hmm.
That doesn't bode very well for you in trial.
Absolutely. Absolutely. So next issue that we have is just what we call modification or modifying a custody order, here in Texas. And so, sometimes people will be appointed as joint managing conservators in the original final decree of divorce or in the original suit affecting parent-child relationship. But then something happens, right? Maybe, Lord forbid the other parent is in a bad accident and perhaps they don't have the ability to make decisions. Maybe they've now been addicted to drugs. Maybe they were arrested for family violence. Maybe they're, using alcohol or abusing alcohol. Various reasons. We've had it where a parent is just making really poor medical decisions and poor educational decisions and interfering with the other parent's ability to come in and make those decisions. And so when that happens, you can always petition the court to modify the child custody order to say, well, I want to either now be appointed as sole managing, or I want the exclusive right to make psychiatric and psychological decisions or invasive medical decisions, etc.
Yeah, and not just to those specific rights, but
Mm-hmm.
you could modify it to who's going to be the primary conservator,
Mm-hmm.
right? And one of the things that we talked about in the Holley Factors, I think that you said, was the child's wishes, right? And so that's limited in scope when it can be used, right? They have to be over 12 and stuff like that. But that's one of the times that the court would take that into account when you're modifying the child custody.
Right. Absolutely. And obviously keep in mind that as long as the kiddos are not emancipated, so under the age of 18, haven't graduated from high school, etc., you can always go in to modify conservatorship. And we've had, unfortunately, cases where we've been back on 4 or 5 modifications for various reasons, right? It can always be modified if there's issues going on with the kiddos that we need to address. Yep. So next is enforcements of child custody orders.
Yeah, so enforcements, most of the time we'll see them with, child support and possession and access, but here we're talking about child custody stuff. So this is going to be enforcing, a parent's right or lack of right to make different decisions. Medical decisions, we see I think that's primarily the one when we see it, right?
Mm-hmm.
Is, parent A wants this surgery to take place and parent B doesn't want it to take place. Whether you have the independent right, the right after consulting,
Mm-hmm.
right? And so what you would do is just file a motion for enforcement if somebody has violated the order, i.e., exercise a right they didn't have the right to exercise,
Mm-hmm.
and then seek that the court, hold them in contempt or, enforce the parent's rights.
And when someone's held in contempt of court, it can be jail time up to 180 days per violation. It can be a mandatory payment of attorney's fees to the other side for having to bring the enforcement in the first place. And then you can also be placed on suspended commitment, which basically means you're sentenced to jail, but you're going to be on probation for a little while just so we can make sure that you're actually going to follow the order. And so, obviously, we always want to make sure that everybody's complying with orders. We take the time to go through the orders with clients so that they know that they need to follow them, they understand it, because if not, there's some serious consequences with an enforcement.
Yeah, and orders are difficult to understand, right? You have to read through them, you have to understand what you're doing. And so if you have questions, just ask somebody, right? Don't presume that you know what you're talking about or that you have that right. If you don't know, ask.
Well, when you say ask somebody, don't ask your Uncle
Right.
Joe.
Correct.
Like
Ask somebody
Uncle
don't know what the hell they're talking
Joe.
about.
No, not the one. He's not him. Obviously.
Or not the
And,
person that's been divorced 5 times that has experience that way.
right. So that's actually the best segue into the benefits of hiring our firm.
It's almost like that was
Because
planned.
good job, Floyd. And so, obviously, as Floyd stated in the beginning, we are, or I stated, I think, we're both board certified in family law. And essentially what that means is we have to have extra rigorous testing and recommendations and applications, etc. And once we go through this very long process, the Texas Board of Legal Specialization qualifies us in the top 1% of attorneys that practice family law within the state of Texas. It does not mean that we know everything. It doesn't mean that we do not make mistakes, because we do. It just means that we're very knowledgeable in this particular area of law because we practice it probably 12 hours a day, almost every single day. And so when it comes to your custody concerns, your custody needs, we know how to address them. We've probably had your fact pattern 1,000 times over. And so we know what we need to do in order to assist you.
Yeah, and we do have offices all over, like Christina said earlier, right? Dallas, Louisville, Flower Mound, Bedford, Midland, Odessa. And so pretty much any of those areas, well, not pretty much, if you are in trouble in any of those areas, obviously we're there. We know the judges. We're familiar with the court system and the other councils in that area. And that's really who you need to hire when you're there, is somebody that's familiar with that. And so we've got the offices out there to help you with any of your child custody issues that you may have.